Okay, so we were dealing with the Citizens Directive. We started speaking about the personal scope of the directive. We said that first it includes the EU nationals, meaning the nationals of the persons having the nationality of the member states. Secondly, we speak about the family members, which includes the spouse, the partner, the direct descendants who are under the age of 21, or are dependents, the dependent direct relatives in the ascending line, including those of the partner and the spouse. As long as the family members accompany the EU citizen, they are also subject to the provisions of the directive, as long as the family members accompany the EU citizen, they are subject to the provisions of the directive. The member states of the EU do not have any discretion on applying these provisions to the family members. The directive also provides, in the break there was a question about the partner. The partner is not the spouse, okay? The partner is the person with whom the EU national has contracted a registered partnership. In Turkish, kayıtlı birliktelik, contracted a registered partnership, provided that, under the condition that the law of the host member state, meaning the member state where they reside, treats the registered partnerships equivalent to marriage. The directive also provide that certain persons, first, I will be speaking about who they are, the other relatives, including other family members and the partner, may enjoy facilitation of the entry of residence to the host member state. This means that the directive do not provide for automatic right of residence and movement within the EU, with the EU citizen for these persons, but the member states shall facilitate the entry and residence of these persons. Therefore, for the other relatives as provided under the directive, they do not have the automatic right of residence and movement within the EU, with the EU citizen, but the member states shall facilitate the entry and residence of these persons. These persons, other relatives, include first any other family members. Any other family members. Meaning, not the family members falling under the definition as provided under Article 2. Who are dependents or members of the household. Who are dependents or members of the household of the citizen or where there exist serious health reasons for the personal care of this person, of the family member by the EU citizen. This group would include uncles, cousins, sisters, and brothers. They are not considered as a family member as provided in the first personal scope of application of the directive. They are not in the ascending line, or they are not dependents as such. They are not descendants, or there are not people in the ascending line either. There are these are other relatives, and they do not have an automatic right of entry and residence, but the member states shall facilitate their entry and residence in the member states. And secondly, the partner with whom the EU citizen has a durable relationship, duly attested. In Turkish, beyan. Beyan. According to the directive, certain rights are provided for the EU citizens and for their family members. The first right is the right to leave. The right to leave. The member states are required to grant their citizens and their family members the right to leave their territories, to let them go to other member states and work in those member states. As long as they produce an ID card, or passport, which would be valid for a 5 years period, which would be valid throughout the EU, requiring no exit visa. We are used to the visas in entry, for entry, but there is a possibility to issue exit visas as well. When the states may decide to issue exit visas, they may require for exit visas when leaving a country as well. Okay, this is abolished in the EU. This is strictly prohibited under this directive, that no exit visa can be issued. The second right is the right of entry. In Turkish, right of entry, giriş hakkı. Similarly, the EU citizens and their family members have the right of entry to other member states with a valid ID card or passport, and there is no visa requirement. Exception is where there exists a third country national family member. For whom visa can be required, of course. If these requirements are not satisfied by the EU citizen or by the family member, according to the directive, the member states shall give them the opportunity to obtain the documents, to have them brought to them, There is also possibility to apply penalty. However, this penalty cannot be disproportional. Meaning, yes, according to the decisions of the Court of Justice, deportation or sınır dışı edilme, or refusal of entry may be considered as disproportional penalties. An example is a decision of Court of Justice from 1975. Watson versus Bellman. In this case, Miss Watson was a UK national. She was acting as an au pair while staying in Italy with Mr. Bayman. Both of them failed to notify her residence to the national authorities, and they face with imprisonment, fines to be paid, as well as Miss Watson's deportation. The Court of Justice found the issue of deportation order as disproportionate, therefore contrary to the founding treaties. One question, where do we provide for these subjects in Turkish law? Where are these subjects provided in Turkish law? Right of entry, right of residence, right of long in Constitution, do we provide them? Where is it provided?
What do you mean, for citizens or
for the entry of foreigners? Constitution? No. In the Foreigners and International Protection Act, we have an act which is called Foreigners and International Protection Act in Turkish, Yabancılar ve Uluslararası Koruma Kanunu. These provisions are found in that act, which is very similar to the Citizens Directive of the European Union. In the second semester, when we speak about international migration law, we will be dealing with these subjects on comparative basis, okay? The provision of this act and the provision of the Citizens' Right Directive. The third subject, the third right provided under this directive is the right of residence up to 3 months. This is provided under Article 6 of the directive. According to that provision, the EU citizens and the family members have the right of residence. In Turkish, right of residence, yerleşme hakkı, right of residence for up to 3 months, subject to no conditions other than presentation of an ID card or passport. For this 3 months period, the reason of residence is irrelevant, meaning it is not important why the persons reside for this 3 months period. It can be study, it can be work, or it may only have touristic purposes. Another right provided under Article 7, the right of residence for more than 3 months. All EU citizens enjoy the right of residence for more than 3 months under following conditions. If they are workers or self-employed persons in the host state, or if they are workers or self-employed persons in the host state, or they have sufficient resources for themselves and for their family members, not to become a burden on the social assistance system of that member state, of host state. Therefore, they either have to have a work as a worker or as a self-employed, or they have to have the sufficient financial resources for themselves and for the family members, not to become a burden on the social assistance system of the host state, and they have a comprehensive sickness insurance, in Turkish, sağlık sigortası, covering in the host state, or the EU citizens that are enrolled at a private or public establishment for study, including vocational training in Turkish, Mesleki eğitim. And have comprehensive sickness insurance and sufficient resources for themselves or for their family members. Under these conditions, the rule is that the family members of the EU citizen, including the EU nationals and the third country nationals, shall enjoy the same rights as the EU national. There are certain exceptions for the family members of the students. You could find in the directive. The next right is the right of permanent residence. This is also provided under Turkish law under this act. The act is pretty new and reflects certain provisions of the EU Citizens Directive. The right of permanent residence in Turkish? Daimi yerleşim hakkı, sürekli yerleşim hakkı. It is provided under Articles 16 to 18 of the directive. This is considered as one of the innovations of this directive. The provisions of the directive on the permanent residence of EU citizens and their family members who have resided lawfully and continuously for the 5 years period in the host member state are given the right of permanent residence. Therefore, the EU citizens and their family members, including non-EU nationals who have resided lawfully and on continuous basis for a 5 years period in the host member state, are given the right of permanent residence. The general rule is provided under Article 16, as we have mentioned, that Union citizens who have legally resided for a continuous period of 5 years shall be given a permanent right of residence. Continuity of residence shall not be affected by temporary absences not exceeding 6 months period. Therefore, the person may be absent in a 6 month period at most, or by absences of a longer duration for military service, or by absences for longer periods of maximum 12 months for serious or important reasons, such as pregnancy, childbirth, serious illness, study, or vocational training. Once acquired, the right of permanent residence is lost because of the absence from the host member state for 2 consecutive years. Please read articles 17, 19, 20 of the directive. According to the directive under articles 22 to 26, the right of residence and permanent residence are enjoyed in the whole territory of the host member state. These rights can only be restricted only where the same restrictions apply to their own nationals. The family members of an EU citizen irrespective of his or her nationality shall be entitled to take up employment in the host member state. The right of equal treatment with nationals of the host member state are subject to the limitations provided in the founding treaties and in the secondary legislation. Other than this directive, as we stated before, Regulation 492/2011 provides for certain employment rights. I will only tell these in brief. You can find more detailed information in the textbook. The first subject provided by the regulation is the right to take up employment. Right to take up employment in the host member state, under the same conditions with the nationals of that member state, without discrimination, the regulation permits the member states to impose linguistic requirements or a requirement of a linguistic ability for non-nationals only when it is the subject of the post, Yes, when, as regards when the nature of the post so requires, then it is possible to impose linguistic requirements for that person. Other than that, there is no such requirement. For instance, in the case of 1987, Groner versus Ministry of Education, Groner versus Ministry of Education, the European Court of Justice upheld an Irish requirement that teachers in Ireland should be proficient in the Irish language as a part of public policy. The idea was to promote the Irish language and Irish culture. Therefore, the court upheld such a requirement, but it also provided that such a requirement must be proportionate. The regulation also provides for social, tax, and other advantages. The workers coming from other member states shall be subject to the same social and tax advantages as the nationals of the host member state. It also provides that the member states have to give access to vocational training to the workers coming from other member states with the same conditions as the nationals of that member state. The regulation also prohibits discrimination on trade union rights, in Turkish trade union rights. Sendikal haklar. It also provides the principal equality as regards the rights and benefits in housing, including our ownership and as regards the rights of education of the children of the worker in the host member state. Therefore, the children of the worker shall also enjoy the same rights as the children of the nationals of that member state in terms of education, including vocational training. Okay, so this is more or less about the most important secondary instruments which apply workers and to services as well. In terms of the right of establishment, we will be dealing with secondary instrument 2. We will mainly in terms of the recognition issue, and we will be seeing also the right of the free movement, the right of free movement of lawyers in the next week. All right, please come prepared to class. Read the textbooks. You will find all detailed information there. All right.